Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
I didn't ask you to interrupt.
Is that correct?
Oh, for Trump's sake. Dati mihi Anglican, boys. Nervous looking.
Good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good morning especially to, oh come on, now you're not going to work. It was just working. Nope, that doesn't work. Why does this button not work, but that button does? Weird. I was going to say welcome to Amy, but apparently I can't welcome Amy. Like, you will not let me. Why can I not welcome Amy? Amy, you have to fix my machine, so it'll let me welcome you. Hang on, let's close this down. Shut everything down, except for the live stream. Keep that going. All right. Quit that, quit this. I think I know what the problem is. I figured it out.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. The computer just needed to be woken up. I think that's what it was. I know it was a short one. But let's see if that fixed it. No. Why in the world? Ooh, I've got another idea. I wonder if my IP address changed. It ends in .215. That's important. That's all I need to tell you. 215. Okay. The switcher does not want to switch. And now it works. Amy, welcome. You fixed it. You did it. Amy, congratulations. You were first in chat today. And apparently you already knew your job. So you fixed the computer. Good job. Thank you for that. We needed it. We needed it this morning especially. Happy Wednesday. We made it halfway through the work week. You know what I did? All I did was I turned on the, if I want to go switch between, let's see, this one here. If I want to switch between this and do it like the fancy dissolve, that works just fine. And I can turn on and off this. But if I switch to this dissolve, guess what I can't turn on and off? That. Is that weird? How it works again. That just means that these transitions that do these funny shapes and things use the same controller that runs my chat overlay. All right. When in doubt, reboot. I fixed it. Everything's working all along. It was just me that had the settings wrong. Wow. Gremlins. Ghosts in the machine is what we call them. Undocumented features. I've owned many cars with undocumented features over the years. So good. All right, where are we? It's 8:47. It's 8:47. I saw in chat not in chat, but on a comment on the live stream the other day. Someone was complaining that that they had to watch 40 minutes of intro before court started, and they don't come here to listen to intro. They come here for court. I haven't yet responded to them, but I think the only thing to do is apologize in true Bev fashion for no one intended to waste their time like this, and we will tell them to begin live court sooner because people are waiting. That's all I need to do. All right, they just need to tune in later. That's it. It all starts for everybody at the same time. I wish I could turn court faster and just make them start when we're ready. It's not how it works. All right, we have a couple people. I saw Natalie's come through, so she's on the list. That's great. Aaron, that's Armand Amber's husband. I did not. She's never told me that ever. I was today years old when I found out that Aaron was Amber's husband. So Aaron, Sienna Sue, Tom, Jan, and Natalie celebrating their birthday with us today. So we're going to celebrate with them by singing happy birthday. That is, all of us are going to sing happy birthday. I already did the hump day cheer. I'm pretty sure you did it with me, so you're warmed up
subject matter jurisdiction.
A little bit. Not yet. But everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, warm up with me if you will. La 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 la. We're on. Perfect. It was like no deviation. This is going to be a good one. Happy birthday to you. Happy birthday to you. Happy birthday, dear Aaron, Sienna, Sue, Tom, Jen, and Natalie. Happy birthday to you. And have a happy day, person who had to sit through 40 minutes of intro yesterday. I do apologize. I didn't mean to waste your time like that. To everyone who's celebrating their birthday today, happy birthday. I realize this is your special day, but you've chosen to be here with us. There could have a million people you could have been with, a million places you could have been. Here you are with us today. Privilege and pleasure is ours. Add Lacey. Okay, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Lacey. Happy birthday to you. Okay, we added Lacey. Is there anyone else we missed? Anybody else? It's your birthday. Happy birthday to all who celebrate today. We got the Add Lacey buffer, but the buffer was wrong. Called you out, Josh. Let's see. I think we got it already. To everyone who's celebrating the birthday today, it's your special day. We want to make your day a little specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's, Andy's Grill, and Bob Evans. There you go. And enjoy the dancing, which is also for you today. Did anyone see me do a split? I didn't look, but I'm sure you pulled it off with grace and flair. Tisha is dropping it. Heather's caught 80s Music Man's eye. And he's got the high kicks. Big drum solo finish. Everyone grab your air drum sticks and help me out with this one. Here we go. Beautiful. Great job. Spin, twerk, pirouette. Wow, Kaylee. Spin, twerk, pirouette. I saw some. There was a bit. There was a bit of shaking down below, so to speak. Good job.
Happy birthday. You look good.
Oh, Judge Fleischer weighed in as well. Judge Fleischer, thanks for sharing. I called you out, birthday, done correctly this time. Okay, there you go. Thank you, Josh. All right, I think that's it. Where are we in the trial? Oh my goodness, we're at day 11. We're at day 11. It looks like I think people are just showing up to court. Looks like so we've got just a minute before before everything starts. Debbie, Creative B, member for 26 months, one of our OGs. I don't want to waste anyone's time. I just want to say how much I love this community. RA and his family. Cheers with red.
In front of the Walmart.
With red Solo cups. That's wonderful. Bug Dugger was dancing in a back brace against medical advice, AMA, I might add. Let's see. Is it 2 weeks or 3 weeks for the state's case? They say 8 weeks in total. So 8 weeks in total, and we're in the third week right now, day 11. It's got to be 4 weeks for the state's case. There are so many people that haven't been called. Brian Albert hasn't been up. Proctor hasn't been up.
Is that correct?
We had a bunch of firefighters round one that did testify that didn't get called this time. They're not up yet. AC's Wildflower is feeling the ache. Advil helps everything at this point after dancing. I've got the Maya interest clock. The problem is the way negotiations and things have gone, it's all gone pretty quiet, and I don't know what the status is. And so I don't know if some's been paid or some hasn't or what is accruing interest. And so I just can't trust it to be accurate at this point. Plus, after the first year, the interest clock accrued differently, and so it's a big shift. Just not sure if it's accurate at this point. So putting it up would be sort of frivolous.
I saw a chicken fight.
I saw Britta Aller, 2 years with this fantastic group. Congratulations, Britta. Today is the day you get your pink courthouse. This fantastic group of true crime friends. Thanks, RA mods and chat. Now in the pink club, I think I'm going to research getting one of these challenge coins made. Thank you to the person, by the way, who sent me this amazing K9 challenge coin. They don't want to be named, but thank you. It is incredible. I love it. And the company that makes it just might be making some for us. Should we do like I don't know. I like the type of coin that's like an AA coin, right? Celebrating sobriety, but celebrating, how long you've been an addict of true crime. I like that idea, but I also want just a general one for the channel. I don't know where to put this extra keyboard. Right here. Stay. There we go. So I've got to come up with a little bit of a design on it, and we'll see. We'll see how it turns out. We are at 106 on our siren counter, by the way, which is a goodly number, if I say so myself. Let's see if we can get that up on the screen. Media, boop. Okay, that and that. There it is. Just pops in like that. 106, mostly sirens. I will say that a couple people have changed their behavior a ton since round one. Probably the most notable is Mr. Lally, who has given us exactly 0 what if any's this trial. 0. And we had 1 billion last time. The judge also has been less seismatic. Whoa. Less psi-prone. What is the word for someone who is who sighs a lot? Siastic? Let's make up a word for that. Less oxygenated. No, it's a little different. Seismic. No, just a psi. Psi is a good word. The state has to call Higgins and Proctor. No way they can't. They've got to get it in there somewhere. But I wonder. First of all, Mr. Brennan is proving the elements of his case, or laying them out, in pretty good fashion. Thank you. appreciate that. In pretty good fashion, without Proctor. I'm wondering if he wants to limit Proctor's testimony for that reason and only bring him in for the little bit he needs to. Sizey. Chronic sire. Sirific. Oh, I like sirific. That is a good one. Jared, Jen, that's sirific's really good. Tammy in Kansas says, happy soggy Tuesday. 16 months have flown by. You guys got some crazy storms. I was looking on the weather guy's page. You know, the guy that testified the other day. I was looking on his page. Even though he just does Boston weather, you can use his radar map and sort of scroll around the country and look at whatever you want. And I figure, why not spend his $50 well and get some more weather reports for areas of the country I'm interested in. So I did look at Oklahoma area, looked at Texas, looked at Kansas, Tammy. You guys did get some great accumulations of the wet stuff, the water. Not enough to track a cat in, but enough. It has to be colder to track the cat. Proctor can't plead the fifth because he testified in the last trial. Yeah, there's no way he can plead the fifth. I don't think an officer in the performance of his duties pleads the fifth. I don't think that's a thing. How's my son today? He looks like a chipmunk. He's got a nice square jaw. Like, it's very different. Can't believe they didn't ask every person on that street for that security footage. The ghost, thank you for bringing this up. Did some research last night because this bugged me so badly. I need a graphic. I need a protractor is what I need. I need a protractor. Let's see, where's a mouse? Mouse first, then protractor. All right, that's going to be down here on 7. Now I need that other keyboard back. Arlo security cameras are amazing little things. Amazing little things. Let's see if I can find a good image that I can show you here. Let's visit this page and see if we can. All right. Anybody want to do a quick website view? How about right here? Look at this. It's a nice little website. Let's check out their website. Oh, they teach us cool things. Where are we? We're at Tobii XR Dev Zone. That's talking about visual angles. On the left here, we have it's a depiction of an eye, but that eye happens to capture 130 degrees top to bottom of field of view. Guess what also captures 130 degrees or 180 degrees field of view? Arlo cameras. At a minimum, 130 degrees. As I looked at that picture, assuming the camera was mounted the same way it is now, way up high above the door and hasn't been moved since they installed it. If the camera was mounted like that, on the day that this occurred in the neighborhood, we're talking about the incident with John O'Keefe, Albert's house, the dude could have seen the northern lights in his security camera. Way up there. He could have seen the street. That's all I'm saying. Anyway. What is the 130 degrees field of view in Celsius? Thank you. The 130 degrees field of view, for those of you who want to do the math on this, it's actually measured angle to angle, so corner to corner, a lot like TVs measure their view, their size, right? I was like, I got a 68-inch TV. You measure it, it's like, why is it so short? It's not 68 inches across. No, from corner to corner. is how it's measured. So 130 degrees field of view. That's wide open. That's like this. Okay, it can see it all. It can see it all. It's the little bit it can't see is peripheral. And when it's pointed down at about, I don't know, a 25-degree angle, that leaves like 90 degrees of sky in the picture. I just don't get it. The math's off on that one. It's not 90, it's less. What's up, bud?
How good was your hump day yell?
My hump day yell? It was excellent. It was always perfect. 2 thumbs up. Thank you, bud. Appreciate that. All right. I hope someone tags him on that, because that's just, it's terrible. Kelly H, instead of membership, thank you very much. And I also, what police officer who has video of a major incident that happened sort of like right in front of you, where there is question of what happened, doesn't go back and look at their footage? What officer doesn't just be like, let me just see if I caught anything. Let me see if my camera picked anything up. Unless it did catch something. And he didn't like what it caught. I don't know. It defies reason to me. Even as a random neighbor, I'd want to check. I will say it does not. It is not proof that something was wrong. It does not prove that there was anything. It just leaves a huge gap for reasonable doubt. That's it. And as more and more of these gaps appear, they start to become, well, a little more than circumstantial. Various. Why would the Alberts, if there was some sort of, pressure or encouragement to not have any video, why? You've got to ask the question. Because that camera, I'm sorry, that camera caught the sky. I stand by that. What if it picked up planting evidence? These are all what ifs. There's no evidence of that, but they're questions that can be asked. Don't forget the media reported there's security video of the incident. I want to look at it from every angle. And so I have to look at it and say, what if Karen did hit him? Miraculously, right in that one part of the body that doesn't bruise. And he fell back. What if Karen hit him and the dog and Chloe had at him? Then maybe what? The Alberts don't realize Karen hit him. They only see Chloe involved and think, oh crap, our dog did it. Hide the evidence. I just don't know. I just don't know. The DA stated that there was ring camera footage of Karen hitting John. Then somehow it just never materialized.
Okay.
So I'm told counsel wants to see me as the jury's coming over. Why don't you come up to sidebar?
Y'all just live up here at the sidebar and we'd be ready to go. Angela says, let me stop you right there. Last week I fell and I still have bruised knees. How did the witnesses see her SUV at 12:45 when she connects to John's Wi-Fi at 12:36? The worst the worst evidence, I think, in the mind of the jury right now is Karen's words saying he didn't look mortally wounded. And I believe that is taken out of context. I think it's portrayed as, when I backed up and hit him and saw him on the lawn, and then we pick up, he didn't look mortally wounded. That's I don't believe that's how it was shared in the video. But I don't think the defense will risk putting her on the stand to face Brennan, who can be a shark on cross-examination, to clarify it. I don't know if they will. All right. Mi Cazador de Ardilla. Or you're blocked? I don't know if you're blocked. Why would you? I don't know why you'd be blocked. Sigh or just dismiss my additional info that was spoken of by witnesses. No trigger. No video. You want me to sigh? I'm confused. Sigh? Oh. Is that it? Genjo says, please read this. Some Arlo cameras have activity zones that can be set up so that anything outside that zone does not trigger the camera to record. Right. But some also are triggered by audio, loud noises. Some can be triggered by pixel changes, which can be affected by light, even without motion. I think it deserved a look. Jennifer Cochran-Fent says, can the defense address those videos in closing? The defense can address them in their case in chief, as long as Karen takes the stand. Once she takes the stand, they can address every one of those. They can play the context around it, all of that. I cannot see a way legally, aside from the judge agreeing that under rule of completeness, more has to be brought in. And I'm not sure if the defense has argued this already, but if that rule applies in Massachusetts, it should be fought for hard right here. The problem is a lot of the videos don't make her look good, and bringing in more of them isn't always a good thing. They can't without her testimony, right? Because it is hearsay. That's the reason. You can't introduce self-serving hearsay without her taking the stand. You can't say, I'm going to exercise my right to remain silent, okay, which is not pleading the fifth, exercising my right to remain silent, and force the state to prove their case. And at the same time, I'm going to play pre-recorded clips of me telling you about the incident without cross-examination. Defense can't do that. Prosecution can. They are allowed to. That is, they're specifically allowed to play recordings of Karen and anything she said. Let's see. I have about 15 Arlo cameras, some at my home and some at elderly parents' homes. Genjo, they're good cameras. They're good cameras, and yeah, they do have all the features you guys mentioned. They're there. I don't think they can play them even if she testifies. It's still self-serving. Oh, if she testifies, she can't. They can. Well, they can bring in the clarification, and I bet the judge would allow them to play. What if they? Oh my goodness, I'm thinking this one through. What if they use it to refresh her recollection of exactly what was said? Is that a way it could come in? Good morning, Woody. Good to have you here. Welcome. Got a sidebar going on to start the day, as we have started almost every day with. I think we've only had 2 days without a sidebar first thing, maybe one. Whose recollection? Karen Reed's, refreshing her own recollection if she takes the stand. S-Bar says, I don't think the clips sway me. She's just saying what she was thinking at the time because she was being gaslighted by so many people. Late but present. I do go back and get these in batches. So if I don't see it right when it happened, I do try to go back and get them again. After Tammy, we had Caden, who's a member for 1 month. Caden, you've got that light blue courthouse. First of many changes. Thank you very much. From Aylesbury in the UK. Aylesbury. Let's see, what is that? 60 feet above, or 600 feet above sea level, I think, something like that. I don't know. Spent some time in Aylesbury, Rickmansworth, Watford. Trying to remember the address I was at. I remember in town in Aylesbury, in the center of town, there's a big bronze statue of like a Spanish explorer or something, and somebody had taken a traffic cone and put him on it, climbed up and put it on its head. I think I still have a picture of that from Aylesbury. Let's see. Late but present member for 12 months. Bev has less diarrhea this time. That's a different way to put it. Congratulations, late but present. 12 months, you hit the year mark. That is awesome. Kelly H. gifted a membership. Thank you. Jennifer, we got your super chat in there as well. Thank you. KRH member for 13 months. Oh, man, missed my year last month. Yay, 13 months. It's been much longer. Carolyn McDonald, member for 9 months. Hi from the Isle of Wight, UK. I think I've got a bank account there somewhere. I've got a bank account somewhere in the Isle of Wight with like 20 quid in it, I think. Baby Bear, member for 24 months, member of the jury. Baby Bear, congratulations. Thank you for your great support of the channel. So happy to still be here with y'all. Best Beast channel ever. Beast channel. That's better than best. It's Beast. Thank you, Baby Bear. Appreciate it. All right. We are, this sidebar is taking forever. The jury is probably waiting outside, waiting to come in.
All right, can we bring the jurors in, Tony, please?
You know, I apologize, missed your anniversary. I do sometimes miss them, and I'm very, very sorry.
You are unmuted.
Now we're unmuted. Somebody snoring, or is that a cat purring? I think it's a cat purring. I think Bev has brought her cat, and it's purring. Lena, I do apologize. What was your anniversary? Which one was it? Well, you've got Orange Courthouse, so it's got to be somewhere between the right around the year mark. Hit and Run gifted a membership today. Went to Christina. Thank you very much, Hit and Run.
Okay, thank you.
Got a buzz on the line. See if I can tune that out. I think it's around 250. It's a weird hum. You don't normally get them that low. So I'm not sure what's causing it. I'll fix it that way. I think the jury's coming in right now. So could be a fan. Some sort of vibration on the same surface as a microphone. As we pan out, looks like the whole defense team is here. Mr. Yannetti drinking Fiji water today, as is Alan Jackson and Ms. Little and Mr. Alessi. They've gone with the branded water. No Poland Spring for the... Oh, there's a Poland Spring in front of Mr. Alessi. He's gone cheap. Everyone else drinking the good stuff. Prosecution all here as well. Mr. Lally had a little activity yesterday with a couple witnesses that he got to question on direct, which he did great on, I have to admit. Elizabeth says, I was here watching Darrell Brooks 2 years ago on my first maternity leave, and now I'm here on my second maternity leave watching Karen Reed. Well, I hope you like kids, Elizabeth, because we've got some great cases coming up. If that's what it takes, so you can watch. Gonna have a big family. All right. Alessi seems like a Poland Spring kind of guy. Started the day with the hard stuff. Newbie 2015 says, I am blessed with my 5th grandchild at 2:28 this morning. Now have 3 girls and 2 boys. That is worth a little celebration there. Congratulations. That is awesome. This has to be costing a fortune for both sides. DSN, it is. It's a lot of money. I would say hundreds of thousands of dollars for every single trial. Maybe even at a 0.
You look good.
Happy anniversary, Iris. Did they ever pull DNA from under John O'Keefe's fingernails? Megan, I don't recall that, but I don't think they tested for it. Well, let me remember. If Karen Reed's fingernails were, or if Karen Reed's DNA was under his fingernails, that would be expected as someone who was an intimate partner.
Judge, while we're waiting for the jurors, just for the record, I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
That's correct.
All right, thank you.
Would all rise, jurors enter.
So one of the jurors wasted the judge's time this morning. That's an interesting change. Brandy Joe. We've got some noise on the line. I do have the limiter in place in case it goes squampus like it did the other day. Won't be so bad.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, good morning again, counsel. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. No, thank you. All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keith.
Connor Keith. Sounds like a firefighter? Maybe?
Come on, sir, follow me. Now step up, raise your thank you.
You raise your right hand. Do you solemnly swear the evidence given to the court and jury in the case now and herein should be truth, the whole truth, and nothing but the truth, so help you God? Yes.
I think he's a Massachusetts State Trooper, maybe.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes.
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes. In various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes.
Were you assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Okay. Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence.
A lot has been said about this shoe, specifically the picture compared to the shoe that's about to be held up. Look at the sole of the shoe when he opens the sealed Stop and Shop
before you
bag.
open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If you hold it upside down, it says
Stop and Shop.
Stop and Shop.
Is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir.
Upside down, it does say Stop and Shop. But uses scissors appropriately. Cuts towards his hand. But safely done. Here is where he explains, my job is to seal the bag, not to open. This is actually a first for me. I'm just going to cut the top off. At least most of the way, not all the way. Oh, you tore it. You break it, you buy it, man. These bags aren't cheap.
With the court's permission, can he show the items?
Yes.
Go. You're not seeing the bottom of the shoe.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag, I'd ask this to be marked as an exhibit.
All right, any objections, Dean?
The bottom is white. See that? The bottom's white. The shoe in the picture, the bottom looks black. I believe the bottom looks black because of a shadow.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who is collecting it.
The time that you write on the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury. Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces, or is there another piece in that bag?
There's another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay.
Objection. That small piece can't come into evidence. There's no foundation for how it got there. While they're doing this, oh, that's not it. We need 8. Nope, that's not it either. Hang on. We need into clean feed. Workspace. There we go. While this is going on, hold tight. We need to show you this. So the picture of the shoe. Well, they're back now.
So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes. Sir, on the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip.
See if you can find it. Did you bring
I'd like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And I'd like to introduce that exhibit.
So, do you have a spare Stop and Shop bag?
So we're going to mark the little chip. Mr. Yannetti asked to mark that. Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk,
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Exhibit 78.
Thank you.
I've got a bag you can use if you, sir, just right here. There you go.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have Exhibit 73, please? Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes.
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
If I'm showing you a photo, you recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
Okay. There's no objection, Mr. Yannetti?
There's no objection, no.
Exhibit 79.
With the court's permission, could we show Exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
Yes.
Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
It definitely looks like taillight material to me. That's not a broken Tupperware
Thank you,
dish.
trooper. I'd move these items into evidence.
No objection, Your Honor.
Right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Ms. Giannetti?
Please, Your Honor, thank you.
Who was the lead investigator?
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts?
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself?
Yes.
In this case, it would have been an iPhone 11?
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number?
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form?
Yes.
And the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well?
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022?
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct, 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the...
I will not.
Exhibit 81.
Now, Trooper Keith, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay. It's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation, no.
You have not yet?
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
What?
If I may just have a moment, Your Honor.
Okay.
Who's mistaken here? Mr. Unetti? Or Trooper Keefe? We're going to count that as a sigh.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach, Your Honor?
Yes.
It's not a clean refresh. We're giving him a laptop. So Brandon wanted to print it out first.
No, not at all.
Do you mind if I show him that? No, not at all. There he goes. So the laptop is good. Having some chat issues, just disconnecting and reconnecting, so apologize if I'm missing things you're saying. Okay, so we do not show them the laptop. The state has a printout.
I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done.
His chat is broken. I don't know why. And Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take
sure,
a look, sir.
Go ahead. Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but...
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
Yes.
Okay. And the two of you would have participated in that interview together, correct?
Yes.
But you did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. Let me approach Judge.
Yes.
Thank you. You're welcome. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. Asking you this. You retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach.
Okay.
Oh, I'm sorry. And again, if you'd read that silently to yourself and look up at me when you're done.
All right, I fixed the chat. We have it back. Sorry, I had to reboot everything. One of the reasons why I like running separate machines for each component. One goes down, it all to kill the stream. One of the downsides of bringing a junior officer like this, which I presume he is a junior officer with him having less time on the force, to testify about things without calling the senior, they haven't been in court as much. They aren't as experienced. They can be led into a trap a little easier. So while yes, the prosecution gets to bring the evidence in without Trooper Proctor's involvement, at least in front of the jury, you get the inexperience can also show.
Okay. Having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. Right. I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
This is C.F. McCarthy's.
Okay. I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes. Again, I only got a copy of the surveillance video.
Sure.
I did not do any analysis.
And with regard to the waterfall bar and grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Okay. Now, another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
Unity thinks he has reason to bring this in over the objection of relevance. A nickname for a trooper. What's the nickname? Nickname has to, it's got to be quite significant if it comes in. Can he plead the fifth if he already testified before? This is a new trial, right? Wrong answers only. What's his nickname? Cat Tracker. You can always invoke at any time. Green as you're choosing the wrong word. Let's see who won that one. If we get the nickname, it was the defense.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of 2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scotti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scotti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. Staines, you can ask that differently.
What, if any, conversations did you have with Dr. Scotti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment. May I approach, Your Honor?
Do you think Brennan will be able to pull off his case in chief with never calling Proctor?
You want this one back?
Oh, please, thank you. So I've placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done.
It would force him to leave out
And I would direct
many
your attention
pieces
to the
of
second
taillight.
page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scotti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scotti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of questioning.
Sustained.
May we approach?
Why is that?
Jurors, feel free to stand up.
You knew that the medical examiner had seen the injuries on the body. I object to the line of questioning. Brennan is objecting because Mr. Yannetti, I believe, is still searching for an angle to get in to that first question he was asking when it came to the ME about Proctor telling the ME what had happened. So I think he's trying to open that door to get that path in. And Brennan is shutting down everything with objections, and the judge is sustaining it. This last question, I think, I don't know why it would be sustained. He's basically asking an observer of the autopsy if he knew that the medical examiner had observed. So is it that his knowledge of someone else's perception? Would that be why it's not allowed? Okay, Nicole, good job. I should have read chat. You were there first. He's asking what's in the medical examiner's mind. But I think the question was worded broadly enough that if the medical examiner had indicated or announced or done something with the injury, that he could answer that without having to like read her mind. We can't say what they thought. That would call for hearsay. What if you were to ask, did the medical examiner in your presence I guess in the indication, but that would be hearsay as well. Yeah, I can see why this would be sustained. Chat is not working on screen today. Sorry, I turned it off while I was fixing it. I had to reboot that computer. It's back up. Welcome to lawyering, says Nicole. Oh, man. It's hard, especially hearsay. So hard.
Were you watching Dr. Scorti-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
Objection.
It's the same thing, just ask a different question.
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do that,
the body.
I'm sorry?
She was looking at the body, I assume.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scorti-Bello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, not
that was a smug smile from the witness. That was we successfully avoided a troublesome area.
Jurors, this break we're going to take now. All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break than we normally take, and it's a little bit earlier, but we did get coffee for you, so we'll take a recess now for the next half hour, maybe a little bit. I want counsel to stay.
All right, so the court, please.
Counsel stay. We're going to. Jury's out for half an hour, maybe a little bit more, she says. The mic didn't all the way. There was got killed. That witness came across like he was trying to hide something a little bit. And maybe it's because Mr. Yannetti did some great leading questions, pointing out what he thought that the witness was trying to hide. He has done the foreshadowing that they left without the medical examiner declaring a homicide.
Seated.
So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response. Then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate...
One's a Massachusetts case, so that's easy enough.
Okay, so, and that's a shall...
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course a court is judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
He's going for the Sandra Birchmore case.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor, and the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it one
the decision.
Right. Oh, yeah, just what's in the decision. But there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
If I could give you the answer, Your Honor, I will explain it. It's a very short answer.
Okay.
What I want to do is, with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple's source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
I made a mistake. It's not about
This is an
Birchmore.
attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple or 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp.
No, that was raised, but this... What was problematic in Maryland? The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor,
okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got advertised on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
You can see the plan to dehumanize somebody, daubertized, to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here is the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled, to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term daubertize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court And one part is the location. She has in her PowerPoint, she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search.
Yes.
They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert, and this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis.
by invoking
It's
the
a
Constitution.
totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
I think Alessi wins this one.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says, ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology. With regard to her PowerPoint, you heard Mr. Brennan's answer. He is going to include, he has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't, in anticipatory, have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
All right, and Mr. Alessi, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this. If they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls, but if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Okay. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's...
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here?
Your Honor, may I ask one thing? May I, Mr. President?
I just want to know, is she here?
She is, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
So this was, the judge is mad because this just came up. Defense just handed her some case law and said, oh, by the way, you've said we can't do this. We can. We can, and here's the case law. Unless he's right, they can. The judge is mad because she just found out that it's not that she's mad that they got to do this. It's that she made a ruling and it's basically not good. There's higher law, case law that says it is allowed, and it's spelled out in black and white. So defense was late in bringing this. She said a couple times, I wish I got this earlier. You know, I'm frustrated that I'm just finding out about this right now, right before the witness takes a stand, that this is a decision. This is a problem. So she is going to read through this. I think she's going to take the full half hour, but her indication so far, I would say that she is going to allow it. The argument that excluding it would encroach on the defendant's rights to question witnesses. That is a powerful one. It's the constitutional one that Brennan was so mad. It's like, they're invoking the Constitution. That's not fair, because it's not that big a deal. The judge is sensitive to that, very sensitive. She does not want a round 3 on it by any means. And where we've got some case history, it says this is allowed in. It's coming in. I apologize. I thought when I heard that announced that they were talking about the decision that we heard the other day to keep the Sandra Birchmore case out of this trial, and I'm the one that brought that up. I was completely wrong. It was not about Sandra Birchmore. That would be a very different trial if that came in, and that's, I think, probably has a higher standard to bring that in. It has to be relevant and all sorts of stuff. But so no Sandra Birchmore. I apologize for that inaccuracy, and it's all about Dr. Hyde. So Alessi is very, very good at doing what we just saw. This is, every lawyer has most lawyers have a strong suit. This is Alessi's. Even with a judge that doesn't like him very much. Goodbye. Goodbye, apparently. Now we get a break. The judge does not. I think Mr. Brennan even sounded a little bit defeated in the end. He could see from the line of questioning that the judge asking, well, what if they don't go into this? Trying to see if she can avoid a decision of this on this specifically. No judge likes to be rushed into a decision. I think Alessi knows that he's losing this one, and basically is conceding and basically just begging the judge. Well, then can I get rebuttal on it then at least, and we can come back and do rebuttal. So imagine knowingly presenting your argument to a judge you know doesn't like you, and you still come out on top. Well, I have to say that is a sign of a good judge. That's a sign of a good judge, because the judge might have personal opinions, might not want to do something, might not like you, but does what's right. That's a good judge. And I think, although I disagree with some of the decisions she made, I think Judge Cannoni is a good judge. Where does the goodbye come from? The goodbye comes from the Zoom audio feed, where people can call in and listen. A lot of times it's people from the DA's office or something that might have the audio going back at the office or whatever. I think Alessi does win this one in some form. Daniel, she's not my favorite judge by any means. I'm frustrated with the times she shows bias, but we can look at ourselves and see that showing bias is pretty human, right? Most of us have a little bit of it, and I can't fault her for being human. But in times like this, when she is, has a preference, and she does what's right even against her preference, I think that's good. Check your burner phone. I will. We're just watching the fan turn right now. Let's see. Judges can be biased, but the ability to recognize your bias and make the right decision in spite of it, I think, is a sign of a good judge. Some of our favorite judges completely lose their temper on the bench, and that's not appropriate, right? There's no way that should happen. Usually, it doesn't happen in front of the jury, but we've seen, like, Judge Carroll in the Maya trial just get red in the face. I thought he was going to blow a blood vessel in his brain. And then be able to stop and reset and take a break and come back and reset and make the right decision. Yeah, so I think that's a sign of a good judge. I can't expect them to be superhuman. Judge Simpson, but I love it. Yeah. Okay, I'm checking. Ooh, Phil. TYO Toys may be designing a coin for us. Oh, that's really cool. That's awesome. All right. Checking the messages. I have a ton of them. Just trying to load them right now. All right. I got the message. Looks like I got them all. Thank you. Thank you. Son's doing great. We've got all the meds we need for him, but appreciate the advice. Little man in the corner. We might have a version of a coin coming up. I'm looking at that. I want it to be a nice coin, something that's that you'd feel proud to own, and I feel proud to be able to give away to people, and people want to display. So, but I also have to make sure the cost is low enough that it's attainable. Coins can be expensive. All right. Judge isn't retiring. She's getting promoted. Let's see. Can I turn the fan down? I've actually got another fan right here on my desk now. That's right there. You can barely see the bottom of it. Blowing on me a little bit. Text Mike. He designed coins for the Los Angeles Sheriff's Department. Has a contact. The judge from Waukesha was really good. Coins melted from recovered coins. Not the gold one. The gold one I recovered is not going to be melted down anytime soon. She should never be allowed to retry this case, but of course, in the defense files a motion to recuse, Bevy judge rules on it. Total conflict of interest. She needs to go. Megan, the issue was the mistrial, the cause of the mistrial. If the mistrial was because of something the judge had done, and it was found that there was a bias and just a ruling that was just so flagrant foul on the part of the judge, basically, then you'd have the judge recused. I mean, there's no way you can go forward again with the same judge. But where the mistrial is because the jury couldn't reach a conclusion on all three charges, that's the same judge again. The judge in Gutierrez and Baldwin was awesome. You liked her? Murdaugh. Judge Newman was fantastic. I like Judge Newman. The Letitia Stout judge, probably the first judge whose description of circumstantial evidence I fell in love with. I think he used the child in the cookie jar analogy. Happy birthday, by the way, to Emily D. Baker. If you got a moment, make sure you wish her a happy birthday sometime today, or shoot her a text or something on one of her videos. That would be great. She's covering this as well. Happy birthday, Emily. Let's see. Her jury instructions were not informed right to the jury, in my opinion. I think I would have liked it differently, but I don't think the law required her to do it differently. And a lot of times there's things about the law I don't like, but as long as it's the law, it does stand. So if we change the law if we don't like it. Koberger judge has a heck of a memory. I love that. Koberger and Corey Richens judge. Oh my goodness. Both of them are fantastic. Can't wait for those two trials. All right. Let's see. I'm actually shocked that the cops and the judge are corrupt and absolutely no one is stopping it. Everyone's just lets it go, and the attitude is, oh well, it's completely unacceptable. Barb, in this trial so far, I would say we don't have any evidence of any direct evidence of corruption. Now don't kill me yet. Don't kill me yet. We have a lot of what I would say, incompetence a little bit. We have decisions that were made that I think were made poorly, that hampered the investigation and its accuracy. We have decisions that were made that were incredibly short-sighted and could be viewed as a favor to someone else. I mean, it wouldn't be out of the realm of possibility to say that some of these things, well, that's awfully convenient for the Alberts. If you didn't knock on the door and go in, that's awfully convenient. And the explanation that's given now, I believe, legally stands up, but still smells funny. We're going to get more. We're going to get more, though. I think Proctor has to come in. Wendy, I'm not going to force you to stay. I'm trying to look at this as a new jury looks at this, who has no information about what's going on, and that's how the law looks at Karen Reed, that she is cloaked in a cloak of innocence going forward. So it's all good. Limited edition coins made from Solo Cups. I like that joke. I think the judge has done a better job in this trial than the previous one, for sure. How can they possibly not call Proctor? Melissa, this is something I'm thinking over. And at the beginning of the trial, I thought there was no way we could get through a prosecution and avoid the Proctor issue. I didn't realize how many individuals were involved with each step of the investigation. And now I'm seeing a slight possibility that they can do that if the Commonwealth is willing to concede some of the evidence in the case. I think there are some items of evidence, specifically taillight, some pieces of evidence that I believe were only found by Proctor, if I remember correctly. There is no way that we can get those in, the prosecution can get those in without Proctor on the stand. The question is, do they need all the pieces? Or would they even have a stronger case without all the pieces? I don't know. Let's see. Everyone, please be kind to Wendy. I addressed her directly. I don't need you guys to. That's fine. And we have multiple Wendy's in here, so don't paint all Wendy's with the same brush. Angela says, I have to disagree with you regarding Judge Beverly. She should have allowed the FBI guy to testify as to how bad this investigation was. In trial number 1? Are you talking about trial number 2? The pretrial decision into trial number 2. Also, how about the fact that the officer's wonderful leaf blower that he said himself works amazingly? Oh my goodness. I've had what was he? Supervisor Gallagher, whatever his name was, that used the leaf blower. I think that is a terrible investigative tool. I think the potential to spread DNA that is very small that you can't see, the potential to spread or blow away evidence where you don't know specifically what you're looking for. It's covered evidence. That's why the snow's there. It's covering it. I think that potential is extremely high. Looking at it from the vantage point that he was looking for some blood in snow, basically a blood slushy, he accomplished the goal. It was effective at blowing the powdery snow away on the top. But did it blow anything else away? Did it spread DNA? Did it do other things that using a different method would not have done? Him standing there like he's the golden child coming up with a leaf blower at a crime scene, it's like, I don't know, it's like an archaeologist and somebody saying, hey, I've got a better idea. Let's just use a backhoe. Instead of using little scrapey tools and scrape away a little piece of dirt from the bone at a time, let's just use a backhoe and shake it and get the dirt off. And look, there's the dinosaur bone. We got it. I invented the wheel. It's not. I don't think it's good. I don't think you're going to see other crime scenes saying, "Hey, maybe I'll get, for the old evidence team, the CSI team. Have you thought about getting them a leaf blower?" All right. Taillight pieces were found on the snow and not underneath. Yes, Angela. And the one piece we've had so far about being on the snow, you saw how quick they were to point out that this was a shovel full of snow that was overturned, and so it would have been on the bottom, but it was now on the top. The further we go along with any found on top, if that's coming in, the more problematic they become. And we've talked about that for a couple of reasons, especially the red, the darker pieces of plastic. The darker an object is, the more it absorbs the rays from the sun and can warm up. That's why the road, being black, with asphalt, heats up and gathers sunlight and gets warm very quickly. If you ever walk in bare feet in the summer, it's one thing to walk on a cement sidewalk, which is white. It's another thing to walk on an asphalt street, which is black. The street is hotter. It's hotter by far. An object like a red piece of plastic in the sun, if it were sitting on top of the snow the whole time, would warm up and be warmer if the snow was melting, which it was doing, right? And it would have been down at the bottom. So finding them on the top is a problem. Weezer, thank you very much for the super sticker. That is your 10th super sticker on a live stream. Thank you. Thank you very much. I appreciate that. Still shocked no one had a Ring camera that captured this. Liz? I said this yesterday, and I said it again. Look at Brian Kohberger, because I think the Kohberger case was the exact opposite, specifically when it came to investigating what security cameras from houses and businesses in the area possibly could have caught something. It's the exact opposite to what they did in the Karen Reed trial. The presumption in Brian Kohberger's case is if you have a camera that functions and is in the slightest bit pointing out towards an area of public traffic, even off the route, the cops want it. They want it because it could capture something. The opposite happened here in Canton. It was, we presume that it didn't get anything because you've sent me a text once before that showed a picture of a package on your doorstep, and I picked it up for you. So I'm pretty sure your security cameras would not have caught anything that happened out in front of your house that night. That logical leap off of a cliff is astounding. And for him, and this is the same guy who thinks that the snowblower is the best tool invented by CSI, by him. Angelique, it's possible that I hear what you're saying there, that the shovel, imagine if you're digging in a foot of snow and you're shaving off an inch at a time with a shovel, it's possible that because we don't know where it came from, that scoop of shovel snow could have been, that had the piece at the bottom, could have been 4 inches down. So your fourth scoop, you flip it over and there's a piece of plastic. We don't know because they didn't document that part very well. They took a break right now. They took a long break after a long discussion. Weezer, thank you. I said that already, but I appreciate that. Still backpack blowers on the CSI budget. Those are the good ones, the backpack ones. Man, you could clean a crime scene like, whew, just get right down to the good stuff. Blow away all the leaves and paper and blood and everything else. Just leave the evidence in the neighbor's yard. Don't think you could go anywhere anymore without being on someone's camera. In Coburger, the reason they go from door to door and say, hey, do you have a security camera? Does it function? Can we get a copy of it? Not with, hey, did it catch anything that night? No, they just said, can we get a copy of it? We'll go through it. We'll find everything. The reason is because people set up their cameras to film the front of their house and the street in front of their house. That's what they do. When was the last time you saw a security camera introduced in court that was pointed so all it sees is the door, like it's looking down? It's like the overhead fan view looking down on your porch. We're just checking for bald spots on the delivery guy. That's all we're doing here. No, you've got a little bit of your door at the bottom of the screen, possibly, and then all the rest of the view all the way up through the yard, except for that one. What's up with the certified copy statement? Chris Dias, Mr. Alessi, in this last little discussion he had with the judge, presented the judge with case law. And the case law is basically that as long as he has a certified copy of a other legal proceeding, even from another jurisdiction, and this is a Maryland case he's talking about, if it's certified, as long as the judge deems it certified, and it is stamped certified, then it shall be allowed in evidence if it's material to the issue at hand. We're about to have expert witness, Ms. Hyde, come up to the stand to testify about cell phone forensic stuff, timestamps, the 227 search, how long to die in the cold, steps, things like that. Her methodology of accessing that data from John's phone, from Jen's phone, from the different extractions, was called into question in Maryland. And in that case, it was deemed unreliable because of the issue regarding Apple source code. Apple doesn't help anybody by saying, here's how we do it. With the right court order, they'll provide the final information and say, this is what you get. But as far as this is how we build our phones, this is how they operate, this is our source code, it's not there. So everybody that has extractions from Apple phones tries workarounds to try to hack into the Apple phone and extract information. And Mr. Alessi is going to attack that with this witness, as long as the judge allows it. And he's going to be able to bring in, if the judge allows it, the ruling in Maryland where her methods of extracting that data from a phone, specifically regarding some location or something, were deemed unreliable. And thus, the jury can infer that it's also unreliable here. See, if no snow, you wouldn't see DNA on the ground unless there's an article of something you can't see DNA. They need that blood before snow melted. Don't think that they blew DNA away. DNA transfers very, very easily. And I would say that there was snow in contact with the blood. And that snow blew away. I think that snow would have DNA on it. That stands to reason. It's not like the DNA just sits right there. Anything that comes in contact with it, if it's blown away, would also potentially have DNA. Nurse Kim was in court and said jurors are very young with a couple exceptions. Most seem to be in their 20s. Waldo, if the state, there are two things that can happen here. Ready? If Mr. Brennan, if his goal is to get all the way through the prosecution without calling Proctor, which with each day that goes on looks more and more to be the case, the defense can call him. If the defense calls him, then the defense gets the aha moments because the state can't get ahead of them. The Commonwealth won't be there to explain and walk people through the problems, right? The text messages, what was going on behind the scenes, who was talking to who about information that, about an investigation that should have been, very, very quiet. Mr. Brennan, thus far, has not let the state get many of those mic drop moments. He's gotten ahead of the pictures of, the beach bikini pictures. He's gotten ahead of all that stuff that would have been, but you didn't do that, did you? That moment where Mr. Alessi or Mr. Jackson or Mr. Yannetti can walk somebody into that sweet moment where they have to admit doing something that they're really not proud of. So Mr. Brennan would have to deviate from what he's done so far to not call Proctor to the stand. But not calling Proctor means that the defense calls him as their witness. And they will need the judge to deem him as a hostile witness to be able to lead, because he's going to be a handful on direct questioning where you cannot lead. I would even say it could be challenging with somebody like Mr. Proctor on the stand on direct without that hostile designation. VZF baby, they cleared the street before the plows could clear evidence, but the plows were running long before they were there and Karen had left. Yes, and the plows might have gone multiple times up and down the street. I don't know. We'll figure out from the plow guy's probably going to be called, at least by the defense. How do you explain the blood being on top of the snow when it's been snowing between when they removed John and then coming up with the soul cups? Dog lover, I can't explain it. I can only tell you that in my head it seems reasonable that when Karen said he was choking and they tried to roll him over when they were trying to do CPR, and they probably heard gurgling from pooled blood in the throat and air being forced through it, that could have splashed or spilled blood on the snow that had accumulated after, up to that point. That's a possibility. I don't know. Proctor is on both witness lists, I believe. But more snow was coming in. More snow came in after his body was removed, and before, and that's what the leaf blower blew away, that new snow. And it was cold. It was below freezing. The snow was very powdery and light, and so the leaf blower was fairly effective at blowing that new layer of snow off. The fact that the scene was unsecured all day is not for nothing. That's just mind-blowing to me. It's definitely not, A+ scene handling. He lost liters of blood. Wouldn't it be where he was? The ground was frozen, they said, so all that blood should have been somewhere on the lawn. Angelique, where did the blood go? Bree says, so my cameras do face and capture 360 around my house, from door to street and from door to garage alley. But I'm in Chicago and have had horrendous experiences, so the cameras are a must. Wheeler925 says, how am I live? No, I need zoom. No zoom. We are all the way live. We've got to wait for the court to come back, unfortunately. Vast majority of snow was removed after body. The vast majority of snow came after the body was on the lawn. I think John was gone by the time they found him. He was exposed to the elements for over 5 hours before he was found. Yes, Heidi, he was declared dead in the hospital because they have a policy that they don't declare someone who appears to have frozen in the snow dead. If they deem it a workable incident, which they did, the ambulance showed up, they started working, they started doing CPR. They don't declare them dead until they are warm and dead, meaning they brought them to a warm place. They're trying to warm up the body, and it's still continuing that resuscitative efforts. That's when they're declared, if nothing happens. Sherry, I'm not sure. I asked this question. I'd have to ask a legal mind who's smarter than me. Where you have a case prior to this one, where Proctor has testified, pleading the fifth is invoking your right not to self-incriminate. So the judge would have to rule that him testifying would incriminate himself criminally, if he proceeded. and where he's already testified and he was not charged with a crime, I don't see how he could plead the fifth for testifying again to the same thing, unless there's something else that they're going to ask him about that would be criminal, that would come out. All right, let's check a couple messages here really quickly. Weezer, thank you very much for that one. Golden Tales and Epic Trials. Member for 11 months. One more and you reach your year mark. Get a new color courthouse. Congratulations. Have we talked about Dr. G's body language of John and Karen? Or Jen and Karen? I was late. I have not. I've only seen the tiniest bit of that. I need to watch the rest. Love Dr. G. He's been a guest on the program a number of times. It's fascinating work. A lot of times I don't base everything on body language and body language analysis, but a lot of times what he says just rings true, feels right based on one of those gut feels you get when you listen to a witness. He's able to sort of articulate why we get that gut feel, or what it was that was happening with the witness that makes us feel that way. And I do like a lot of what he does. VZF Baby, member for 17 months. They cleared the street before the plows could clear evidence, but the plows were running long before they were there, and Karen had left. This is true. We'll get to talk to the great snowplow driver who drove the Franken truck. All right. Had to drive to work and it was a mess. Did I miss anything good? Virginia, I'd say yeah. There was some good discussion. The argument that immediately preceded this break that we have right now, which is going to be, well, all in all, probably about 45 minutes to an hour long. It's going to take us almost all the way up to lunch. It was a spicy argument that was well fought on both sides. All right. Love and Life says, I watched a channel where they are confident Karen is guilty. They believe the evidence is so overwhelming there's no way she wouldn't be found guilty. I find it so crazy, the different sides of this case. I agree. I think there's still a lot of questions. I am open to the possibility that she is guilty, but I have not seen evidence in this trial or in the preceding one that would show me that the state's theory of how things happened is what happened. I think that there's a possibility she might be guilty. I don't see any premeditation. I don't see any even intentional act on her part that could be, that could have, it would be manslaughter at the best, basically. But the way the state lays out the story, it just doesn't add up. The science part of it does not add up for me. I'm curious as to why a body can be hit by a car and thrown that far and not bruised. That doesn't stand up to the smell test. Also, curious how the injuries occurred and why they did, and then you've got to just ask the question, why, with the shoddy investigation, with the improper actions of key players in the investigation, Mr. Proctor, I'm looking at you. It leaves room for doubt, a lot of doubt. And I can get past some of the things. For me, I'm past the 227 search. That does not bother me. I accept Mr. Whiffin's explanation as reasonable. I can't say I know it's true because Apple doesn't give out their source code. All we can say is that he very effectively demonstrated the process using his phone and using that tool that tracks it. And as a tech guy myself, replicating a problem like that, that holds up. That holds water. What was the fight about that I missed? Virginia, it's about allowing Mr. Alessi to question, what is it? Is it Dr. Hyde? About her methods regarding the cell phone analysis, specifically the 227 search, location information, things like that. If there's another mistrial, there wouldn't be anyone left to pick for jurors. I think you might be right. They might have to get a change of venue. No broken bones other than the injury on the back of the head. Right? That is the whole cup thing. I think last time Arca said the thrown cup could have shattered the tail light, but then the cup was with him. I mean, how often do you throw something at a moving object and it hit it and bounce back and come right back to you where you are? I mean, maybe if you're falling and you throw a bouncy ball down, but, you know, the base of a cup, you explain that one to me a little better. What gets me, says Susan, is that she said, I hit him, so she knows she did hit something. I've thought about this one, and I can't base guilt on this comment, because she could have been saying, I hit him, like that, and that means something completely different to, I hit him. That is different, and even the second way, you know, the confirmation, asserting a truth in that manner, could have been when it was she's trying to put things together in her head, and she's like, it must have been me. I guess I hit him. Not saying that I have knowledge that I conducted that, and hearing somebody else tell me what she said. Especially after I've heard her voice and she's, Gary, Jen, she's all over the place. I hit him. Does that mean something else? I can't just say that just because the words verbatim said I hit him mean that she said that. She knows she said those words, but I can't say that that's a confession. 2 different glass cups. They were tested, said Peter Steele. There was a piece, if I remember right, Peter, correct me on this one. There was the glass base that we have next to his body that may or may not match something in the Albert's house, or may or may not match something at Waterfall, right? And then there's another piece of glass out in the street. And the piece of glass out in the street did not match either, right? RA is saying, I hit him as like the guy in My Cousin Vinny's saying, I shot the clerk. I haven't seen that, so I don't know. Why wasn't she in handcuffs if she said that admission of guilt? Great question. But we've been questioning a lot of things the police did that morning. She wasn't arrested on site after screaming that next to a cop. And she had max 3.5 hours sleep. And with all the texting she did and calling and voicemails, there was not much sleep. Alcohol was involved. There's just a lot not to just take it at face value. She told her dad on the phone that night she thought she hit something. What about that? Virginia, I'll have to listen to that one again. I can't recall that testimony or where it came in. Was that through an interview, or was that through trial testimony? The one on the bumper didn't match the one under him. Okay, so the glass on the bumper, how do you get glass on the bumper if it doesn't match? How do you think the glass base ended up there? Dog lover, I have a hard time seeing how that glass base could be in his hand after a car accident. You know, if the state says that he got hit by a car, if we're supposed to accept that as what happened, and he was holding this cup in his hand, and when he got hit by a car, the odds of that cup, which shatters all except for the very base, staying in his hand or with his body and flying right out to where his body lands, I'm not seeing that. Just like his phone under his body. I know some people are saying his phone could have fallen out of his pocket while they picked him up. That's not how it was described. It was described that it was under his body. Sandy, oh my goodness. Sandy gifted possibly 10 and 20 memberships. Holy cow, Sandy. Thank you very much. Debbie says, long break poll. Will Bev come back and say sorry for wasting your time to the jury? Well, I think she's blaming the defense on this one because the defense just surprised her with these case law things to read. Yeah, so his phone and the base of the cup end up right with his body. That's like rolling 6 dice and accidentally having them land on top of each other. Or 3 dice even. Roll 3 dice and oops, they all landed on top of each other. It just doesn't happen. Is it possible? Yes. Does it happen? No. Do you think Karen Reed will testify? Anthony, I want Karen to be able to explain the videos and the interviews. And I believe that just playing more of the video, what came before, what came after, would in many cases very much change the impression the jury gets from the clip that was played by Brennan. I think it's fair that she should get to do that. I understand somewhat the rules of hearsay in court, and for her to get to play those, she has to testify. Having seen some of those videos where she was interviewed by journalists, okay, who are just curious and asking questions, these are not trained interrogators. These are not seasoned litigators. These are not courtroom professionals. I worry for Karen's ability to hold up under cross-examination by Mr. Brennan. I think it would be a terrible idea for her to take the stand because of cross-examination. And you can't just testify to some and then plead the fifth or anything else or invoke your right to silence later on. That does not work. If you it's part, or you have to do all of it. You can't say, I just want to do this part and nothing else. It's rarely a good idea for the defendant to testify in their own defense. I don't think it's good for her, which means that they have to either through another witness, like the reporter who did the interview, have to bring in more statements, but even then, I don't think they can, because it's hearsay. They have to just trust the jury on that one. Can the defense call the journalist in? Yes, they can, but the journalist can't testify to what Karen said, because that would be a hearsay statement. It's something that the prosecution can bring in, but defense cannot. This is why one shouldn't drink and drive. Always good advice. Moonpie NC, love your name, by the way, North Carolina, Moonpies. Please explain membership details. Thanks to whoever gifted me. Moonpie, first thing you should do in chat is just type !seat. Because you being a member, we have a reserved seat for you. It's virtual. It's on the front row. So you get to move up to the front of the room in the gallery, and you get to enjoy that reserved seating. You also are exempt from slow mode. That's right. Other people who are not members, who are just subscribers, everyone can chat, but everyone who is in slow mode, especially when it gets busy, has to wait a period of time before they can make another comment. It helps us slow things down so we can read all the comments. When we get more and more members, that's less and less effective, but you're exempt from that. You also can help yourself to a wealth of emojis. A wealth of emojis. We've made custom emojis symbolizing a lot of things. Funny moments in trial, ideas that can be expressed with a simple picture instead of words. Oftentimes, some of the words that we don't allow on the stream can be represented with an emoji instead. Like for instance, a vacuum. A vacuum is a great emoji to use. And if you don't know what the vacuum means, just stand in front of the mirror and mouth the words. Mouth the word vacuum. And now you know why we have the vacuum emoji. Aaron Blackman says, all right, why not put her on the stand? AJ, Karen, did you kill OJ? Karen, no. done and over. Limited cross and full interviews come in. She took the stand, right? Or is it not that simple? Not that simple. Defense would have the right to go into cross-examination beyond the scope. And that first cross could be pretty broad. They could play the uncut interview like they did in the MB trial. Stonehouses, I wish I knew if the defense had this. First of all, I believe Massachusetts has a version of the rule of completeness that we've seen in many other courts, where you can argue that, yes, you can bring that in, but you're bringing in a portion that makes it sound different than what it is. And under the rule of completeness, we're asking that everything be brought in instead of just that piece. There's got to be that version of the rule, and the defense must have argued that. Or maybe they say, we'll take it. It looks bad, but we'll take it. We can deal with that. Because maybe the rest of the video also doesn't make her look good. If you're in gray, don't think you're unloved. We do have a special song just for you that we've composed called Gray is the New Green. And occasionally we'll play it for you and let everyone dance and chat in slow mode. Amanda H. Love my vacuum. Getting things done, right, Amanda? I wouldn't want to be crossed by Brandon just the same as I wouldn't want to be crossed by AJ. Both are absolutely fabulous at digging in their heels. What I love about both of them is when they smell blood, they are like a shark. They are unbelievably effective at chasing something down. And witnesses, for whatever reason, are rarely able to spot the trap. They are so good, and I love watching both of them work like that. Let's see.
That's your clean copies for evidence. Enter your participant. Please enter the pass. You have joined the meeting as an attendee and will be muted throughout the meeting.
Please be seated. Court is in session.
The host would like you to unmute your microphone. You can.
All right. I appreciate the time. I appreciate people's patience. So, in reviewing the rules, I look at Rule 2. So, Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so, upon reflection and consideration, it says, these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
You are unmuted.
Christy, do you want this under that?
Interesting decision. I would have thought it went the other way. So the Maryland stuff is not coming in. I wonder if Alessi is going to attempt to, on cross-examination, ask if she's ever been excluded or deemed, in a Daubert hearing, deemed that the information can't come in. The citations, sounds like she both denied and approved. She approved that he can cross-examine. That was never the question, though. She denied the the bit that they wanted to use. I didn't follow the logic on the case law. She said, based on the fact that rules are meant to, make court effective and efficient, and you told us late, so late disclosure keeps it out?
Put it back in session in ABC.
Jurors, I appreciate your patience. So, your next witness, Mr. Brennan.
The Commonwealth calls Jessica Hyde.
Here she is. Here's our expert. He can cross her, Cindy. He can cross her about his methods, but he's not allowed to bring up the Maryland case where the court found it in a Daubert hearing that it would not be allowed because it was not not peer reviewed. That I would put a strong check mark in the for appeal category. And that's the first one I think that I've seen during this trial from the judge.
You solemnly swear the evidence given to the court and jury in the case now and here and the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Oh, she's nervous.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica, space HYDE.
Space.
What do you do for a living?
I'm a digital forensics examiner. I'm also an associate. I'm also an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
She is scared.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University, not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, etc.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm
review...
so sorry.
Too fast.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are three types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching. But I also have a team of instructors. So, for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
She's a smart lady.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store and you can actually download millions of apps. There's like 6 million apps between the two stores.
Not a sponsor.
Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
This is in their
wheelhouse. Were you
wheelhouse.
asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. on local time here in Norfolk on January 29th, 2022 from the device I was provided, yes. Not the device, the forensic image, for clarity.
So before we get to the two opinions that you were asked to consider, or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 time frame. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually three, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran two different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Great Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual, and on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup, and I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted, or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo. Any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So, for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for sporting events at that school system, I assume, or county location. There is a timestamp for the search Haas Long to Die in Cold. However, that timestamp isn't about active searches, it's about the time that a tab was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background or, if it's never been moved to the background, the current search. So the time, in the instance of the It's Raining Men video, is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is Haas Long to Die in the Cold, because that database holds the current search, it constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put together an exhibit that would show that.
May I approach?
Yes.
Okay, that explanation was a lot clearer than the rest of the explanation that she started with. I saw in chat a lot of you were a little bit lost on what she was saying, and it was heavy on the technical side. Even her explanations were somewhat technical.
Handing you
but she did better on the
paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the exhibit that will help you explain?
It will.
And move this to evidence.
Can we approach you? Or have that bit of jacket if you want.
Come on out.
Can we approach, or I can just object? We are going to approach. Yeah, an objection is a quick way to require a sidebar. Let's see. Please explain how Karen's phone dialed and left a message, but none of Jen's did that. Oh, wait. Bree, I think you're talking about the butt dials, right? Jen had, 7 butt dials that never went to voicemail? That means you butt dial and then butt hang up before you butt voicemail. It's a lot of butts. It's a very talented butt. I don't think Jen's butt is that talented. I don't know. I don't know how you can expect us to believe that you have multiple butt dials in a short amount of time, and none of them go to voicemail. But Karen's do. Is that what you're talking about, or did I conflate the issue? Karen's phone dialed and left a message, but none of Jen's did. Are you talking to John O'Keefe? Brandy. It's raining men. So Hoslan could have been searched at 6 o'clock, but the tab opened at 2:27. Joe, that's what she just testified to. And that is, well, that's very similar to what Mr. Whiffen testified to. Mr. Whiffen testified that the 2:27 was when the tab was opened. She's testified that that stamp is from when it was either closed or put into the background. So slight difference. I think defense is going to jump on that a tiny bit. But it's a big enough difference that it's a different time. It's recording a different time. Pulled up the witness. She's got some great posts online on LinkedIn. I found a photo of her. This is from, let's see, like 5 years ago. Participated in the Women Forensics Camp at University of Notre Dame with several interns and examiners from St. Joseph County Crime Lab. It's amazing to see these young women teach high school girls interested in DFIR. Her future is bright. Read more about both the amazing camp and incredible program making college interns sworn examiners in this post while I interview Julie Gately, Alexandria Lexi V, Laura Hernandez, and Brianna D. That was Jessica's post. So a few photos out there you can find of her. You said George Mason, right? Jessica Hyde. Interesting witness. The objection here, we're going to see what this rules on. I'm pretty sure the state's going to get to bring this in. Whose phone are we talking about? Jen McCabe's particularly here. Hoslang to die in the cold. But the objection was to the PowerPoint presentation this witness brought along with her. And remember the strong argument we had before this witness took the stand? Defense is fighting this one. This is a big issue for them. They need to win this. They need to sway some jurors. And if they can keep some of this out, that would help. Close my tabs daily. I have, let's see. I have 471 tabs open right now.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
Chalk?
May I look at my copy of the chart, or no?
No.
Why don't I just ask you?
See if you can answer the questions, and if you can't, let us know.
Yes, Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search, how long to die in cold?
Correct. I was looking for two searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also used Magnet Axiom?
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
Shameless plug.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image, and that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize, I also used ArtX and Mushy. But the, ArtX is capital A, lowercase rt, capital E, lowercase x, and then Mushy is M-U-S-H-Y. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrate Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundation's paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
Oh, the software updates all the time. Typically, we get an update about once a month, and to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
Teach the hard students too.
You mentioned that Celebrite showed the search on the report as How Long to Die in the Cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out, went and found it, instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, "How's long to die in the cold," where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab, and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
She says both
when
database
a URL
and
or a
database.
search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or of the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how's long to die in cold and how long to die in CIKLD, excuse my differentiation there, both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question yet.
Okay. Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those, and I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for BrowserScape DB, Cloud Tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those, and then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD, CIKLD, CIKD, CIKD.
And finally, at 62447, did you identify any artifacts with that search that appears with the timestamp of 22740? Did you find the same?
Correct. At 624, we have two timestamps in the same two locations for how's long to die in cold, the Knowledge C and the Mobile Safari plist.
So based on your analysis,
there it is,
in that issue, did you come to an opinion whether or not the phrase "how's long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no.
Can you repeat the question, please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how's long to die in cold" was searched at that timestamp tab of 22740?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at sidewalks, Mr. Leslie.
Mr. Brennan's like, I don't smell what you're laying down. I don't smell what you're stepping in. How am I supposed to ask the question? Been a couple objections here as we've got to the end, really the final, the crux. What was the word that Mr. Alessi used to describe the final statement of a paper? He had a really good word for it. I forget what it was. Maybe if you guys remember it, please remind me, because I've never heard that one before. We're getting to that point where she's going to, we've laid all the groundwork. She's told us what got us to this point. Now she's just going to wrap it up and put a bow on it and say, it's my opinion that search, how long to die in the cold, and how long to die in cold, I don't know what that one is. You have to be careful what you say there. Happened at 6, whatever, in the morning. It was good that you forgot. What was the word? Do I have to go back? Mr. Alessi, not conclusion. It was it wasn't conclusory. It was some. Break out the replay machine. Here we go. Where are we at? What he was saying, actually, at the very end of the document. Let's see if this is it. I'm going to keep the audio and video from court going and just play the replay sound effect here.
Your Honor, we have not made a decision on what data forensics expert we're going to.
That's not it.
Say, yes, I need to address the 227 timestamp. And
I'll try to find it. I'll find it. We'll get it. It's a little confusing for you guys when I play sound from a different video. All right. Was not summation. I didn't miss it. I just chose not to highlight it. There were other things you could have gone to. The whole when you're planning on buying a anniversary gift for your lovely spouse, you might use that private browsing. When you're buying Christmas gifts for the family. And I would say that, possibly when you're doing searches on terms that are brought up in court that you don't want on your history, you should probably do that as well. Oh, man. Dopperize. Not that one. It was summation, synthesis. We're getting closer. We're getting closer. I'll find the word. Isn't today the deadline for ARCA to gather evidence to the Commonwealth? It is the 7th. I think they'd have it by the 8th, right? So, yeah, that report should be coming in. It was fancier than synopsis or conclusion or conclusatory, or it was a fancier word. It was an Alessi style word. I think he said shank instead of Erica. That was different. The shank that was I think that was Alan Jackson who said shank. It's anything you don't want Alexa or Siri to prompt you with in future searches. You should probably do it in private browsing. No, Kurt, was that the one? What does that mean? I don't want to say it in case it's a naughty word or something, but I will type it into Grok and ask Grok. Did you go back and look it up? No, Kursan. Well, let's see, anatomy, etymology. Okay, so in etymology, posticum is derived from Latin posticus, behind or at the back, from post or after. The term reflects its function as a rear or secondary feature. So that might have been it. That was the only uncommon word I can think of. It made the notebook list, right? Remember that for next time you play Scrabble. Are the apps installed on my Android considered private? Anna, I don't use an Android. I'm pretty sure almost every app on Apple tries at least to find out everything else you do on the phone. And they have to prompt you now. They have to say, will you share your phone data with, and always say no. Always say no. I'm not sure if that will actually prevent it from being shared, but it's always best to deny. So if I have a tab open for a week and search new things, it will never update. This is BS. Ashley, the tab status, I forget the name of the directory, won't update. It will just have the entry for when it was opened. Actually, it only shows up when it's closed. There will be other entries. There are other, the knowledge database is going to be entered, and that'll have a timestamp of what's happened. But that one about the tab, you won't get any information until it closes, or it's put in the background, apparently. MI5 uses Apple phones. I know the government has tried to sue Apple because some of the encryption is too good. So if you delete history, does it delete current tabs? I don't think it does. I rarely have to delete anything off my phone, so I'd have to give it some tests. We're back. Long sidebar. Let's see if she's able to give her conclusion.
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How about
Sure.
through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
I don't think she's answered the question.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, how's long to die in cold.
I think defense is going to object again.
Correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase, how's long to die in cold, was made at the time of the timestamp 2/27/40?
There's the objection.
It's the last time, Mr. Alessi, on this issue, okay?
That's the last time, Mr. Alessi. You could say that at sidebar. I'm sorry, you could have said that at sidebar and that would have been more appropriate. That's not cool, Judge. Yeah, she spanked him in front of the jury. I'm fine with the judge spanking Mr. Alessi. All she wants. Spank away. But do it at sidebar, not in front of the jury on mic. I see Mr. Alessi's argument here. The questions were not very artfully answered. They're like, he says, are these accepted? And she's like, I've taken lots of classes. Your procedures? Yeah, I've taken lots of classes. Are they generally accepted? I think there's specifics here that Mr. Alessi is targeting. And the general, we write lots of papers on the proper procedures to follow. I think they need more on this one. This is a very, very recent change to how cell phone analysis was done. And it changed because of this trial and basically right before this trial, the previous one. So I think spank away was not what I was expecting here today. Well, there's your bingo. There's your bingo, Bud Dial. I like the witness. She's really smart. Mr. Alessi successfully kept her PowerPoint presentation out. That's a win for the defense because this particular witness is hard to follow just verbally alone, as all you saw. I mean, a couple of us understood parts. Some of you understood all. But she's very technical, and her explanations also leaned towards the technical side as well. So without the visual presentation that maybe a juror would be able to grasp that concept with, I think that was a win for the defense on that part. Obviously, the big win they want is to keep her testimony out that the search didn't happen at 2:27. The jury knows from Mr. Whiffen that the search happened at 6. This would just be a second witness testifying the search happened after 6. So we'll see. Yep, we've gone from light back to fan. Whoever I was debating with earlier about Bev not being biased, I apologize. Today's been a rough day for me to stand by I like what the judge does. There's 2 things now today alone that I don't think was right. Perseverating. The word had to do with what I was looking for from Mr. Alessi. The word had to do with, I believe, the conclusatory or the final ending statement. Remember how it said, this witness, it was actually like the title of the conclusion of the ruling. That's the part. What was said to Mr. Alessi, I was preoccupied. Well, the judge, when Mr. Alessi objected, he said, "Judge, I object. May we approach?" She sighed, which I'm going to count. Give me a second. There's the count right here. She sighed and said, "This can be the last time on this, Mr. Alessi." And then she got up and went to the side. So that's not good. I've heard judges screaming at the lawyers, both sides, says Rosemary. I also think that's not good. I'll get the replay ready.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 2:27:40 was, whether or not that was the time the search "how long to die in the cold" occurred. Can you tell us to a reasonable degree of scientific certainty your opinion about whether that search, "how long to die in the cold," occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion to a degree of scientific certainty whether there was any other searches similar to "how long to die in the cold" that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
Do you
thought.
have an opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6:24:47, "how long to die in cold"?
Same objection, Your Honor.
Overruled.
Just ensuring that I have the question correct.
She's struggling.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Okay. Did you develop a chalk that I showed
I did.
you earlier?
Yes.
Like to approach?
Yes.
A chalk?
Again, I show you. Same document. You recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move, subject to redaction, that this be introduced into evidence.
Your Honor, I have no issue with regard to the redacting aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. Your rights are safe.
Thank you, Your Honor. Appreciate it.
Exhibit 82.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
If we could take a quick gander that direction, that would be great.
Could we enlarge the first two?
Now we can't see
We're
the
going to need
rest.
to get the right column in if we can, please. Thank you. Ms. High, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left it says 2:27:40 a.m. and then under the search term it says How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store, how the data is stored, the search term How's Long to Die in Cold with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record.
Mm-hmm.
What is the term?
Cache.
And what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the Mobile Safari P-list, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students.
I don't think
so
she
that
likes
Knowledge
Apple.
CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see How's Long to Die in Cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 624.47 and also appears up at 227.40?
As mentioned before, through testing of the artifact for browser state DB, that artifact will hold the most recent search that happened in the tab. So it is logical that how long, HOS long to die in cold, was searched at 624.18, tracked in that mobile Safari P list, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for browser state DB, which again has the time that the tab was opened, or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 227 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the how long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that How's Long to Die in Cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are two other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, how long to die in cold, was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important, so we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log.
We're talking about cell phones?
Until the database is closed, and then when it's reopened, all those changes are made.
Can I place my
additions
order?
and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those wall files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table. But it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file.
Who ordered the pizza again?
Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database. So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of how's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file elements such as the search for the YouTube video, It's Raining Men. Because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the How's Long to Die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the wall file for that reason. It doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database. But you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web, that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parsed, so every tool chooses to do that differently. That does not mean deleted, it means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the dataset generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting. Because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp, or Signal or Telegram, those would each count 2 and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not on the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
So do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see counsel at sidebar regarding scheduling and a few things?
Scheduling and a few things. Scheduling and a few things. Let me see if I can go back and play the last. Let's see the last break. Was this the one? Okay. See if we can hear this. Ready? Just listen. Sorry. Why is it playing like one? Does not want to play right now. Maybe it's because I have. $73 hours of video in my timeline right now. Is that possible? Let's do a single clip instead. See if that'll play.
If it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
This was what happened a minute ago. Looking for the objection and the judge's response. I think this is right here.
Handing you a piece of paper.
Fast forward, fast forward.
You can call now.
Oh, that was the wrong objection. Fast forward through this. I think it's right here. Next objection.
To an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at sidebar. All right, Ms. Hyde.
Sorry.
Let the jurors.
We're back now live. Trying to find that.
Thank you, Your Honor. Thank you, Your
Jurors
Honor.
will recess for 45 minutes before lunch.
All rise for the court, please. Jurors, close your notebooks. Follow me.
45 minutes for lunch. 45 minutes for lunch. And we'll be back. You need a clock, a new clock. That was a lifetime ago. It was a long time ago. I can't find it. All right, it's reminded me of watching film in high school football. It's a little more fun this way. I've got the little knob. I wish you guys could come play with this. This is a fun tool to do some rewinding on. When did she say that's the last time? Maybe it was right here. Just 1 second.
Okay. Scientific certainty. What is your opinion about whether the phrase "how's long to die in cold" was made at the time of the timestamp 22740?
It's the last time, Mr. Leslie, on this issue, okay?
That was it. It's the last time, Mr. Alessi, on this issue. Okay, that's what she says. All right, we made it all the way to lunch. What are we looking for? I was just looking for the judge part when she told the jury that she was frustrated with Mr. Alessi's objections. That I don't think that was good. Let's see. You seen the clip from DUI guy with the eye contact between the judge and Brennan during the arc of voir dire? I didn't see that as a big problem. It's not like it was a what do they call those meetings that they did all the time, the Young Thug thing, ex parte meeting. How long till pizza arrives? Same objection over and over. Trying to plug in my phone. Wait for it. Wait for it.
Call from Angela.
Angela, how are you doing?
I'm doing good. You?
Good. My pepperoni pizza got sent back to the kitchen, and I'm still waiting for lunch. But other than that, I'm good.
Yeah. Well, we're interested by the defense about that move to regarding Jessica Hyde. And to be honest, she lost me, and then she picked me up again when she started talking about papers and books and so on. And I just happened to be in the library, so yeah, I started Googling her. Yeah, so yeah, that's interesting. So there are quite a few papers actually written on SQLite.
Yes,
I have to admit, and not all of them shows them in the bright light. They show. So I think that's one of the things that now I understand what the defense wants to point out. SQLite is not a new program, but is very, a lot of papers does say it needs improvement.
Yeah.
It's not the same as Celebrite and others, and that's why it's also not as, I'm not saying it's not believable. I'm saying it's not as
reliable.
It's not the same. Reliable, right? That's the word. So they mentioned something like SQLite has like 7 search something, and while Celebrite has like 10 or more than SQLite has, and that's why it's not as reliable. But it is good. It is actually catching up faster on iOS updates than other programs.
So
that's the positive side.
Tell me this: the scientific her findings, the end, the two things. Do you believe her?
Mm.
Does it hold up?
I mean, if I have a hard time believing her.
Okay. All right. That's all we needed.
Because simply the FBI guy says the 227 happened, the Vanity Fair person said 227 happened. Defense has a Google employee coming to testify to verify that the 227 happened. You know.
That'll be interesting.
So,
I wish they could verify it from the Google side.
That's why defense has a Google employee.
If Google can say we got it at 227, that's case closed.
Yeah.
That'd be interesting. I'll watch for that. That's going to be an interesting testimony.
So, and it also, speaking of Google, let's put Google and Ayden within and the others aside. In the first trial, when they first showed extraction of all Google searches she did that night, there's this MAC number. I don't know the name of that tab, but it says some kind of a number. And it basically what the number represents is the move you made since you first opened the phone from the factory, or since it was the factory restarted.
Okay.
So, and it shows Google searches in order. It was, let's say, 463, move 463. She Googled the Raining Men. Let's say that she Googled.
Okay.
And then 464, she Googled Cost Long to Die in cold at 460 at 227.40, and 466 or whatever was whatever she Googled after that.
Okay.
So those numbers represent the moves you made on the phone from the day you opened the phone until today.
What about her phone calls?
Sure.
Weren't there calls?
Including phone calls.
Okay.
Including phone calls. So, but I don't remember if they were like that. I just put some random numbers in that came to mind. So when you put them, if that Google search happened later in the day, that MAC number or whatever tab name is that would not fit with the other moves on the phone. That was shown in the first trial. I don't know why are they not showing in this trial.
I think they're trying to keep the first trial had a lot of stuff that wasn't relevant. Like prosecution brought in a lot of testimony that didn't matter. People that didn't really bring add anything to the conversation, they were just, and I was also there, and I don't really have anything else to say. I think they're trying to whittle that down because there is some pretty technical stuff they're asking the jury to understand. So I think they're just trying to focus on just that part, limit it as much as possible, not bury them with all the data. But it's interesting. I wonder if it will come in maybe on defense.
Well, I found, and also it's funny that she says that sorry. Okay, I have to go.
All right.
But yeah.
All right, we'll see you.
Yes.
Bye.
See you. Bye-bye.
Work is calling. Boss just came in. We have to go. Bug Dugger gifted a membership. Thank you very much, Bug Dugger. Whisk Brand said, it's not just one, but all the judges' remarks of the defense attorneys combined that will affect how the jurors view the defendant, R.A. Thank you for that. I think the jurors are seeing that. That's very important. Brandy Joe O says, I'm behind, but could they ask her if people have been found guilty based on time searches, but could have been found not guilty using her method? I don't think she'd be the person to ask about that. Possibly the Celebrite guys might be. I think the question would come in more along the lines of, have you ever been asked to testify about this particular database before? That's how it would come in. I can't think of any cases where this happened. In this case, puppets actually would have helped the food and cash explanation. I'm just saying, says Judy. Or interpretive dance. All right. Corn and banking. Yes, that's what we covered. That's what we covered today. All right. We only have about half hour before we come back from lunch. So make it quick, make it snappy. We've got a portal set up we can jump over. Let me make sure I didn't miss any messages before this. Snarky Old Lady says, I could have had a baby by now. 9 months. Thank you very much, Snarky Old Lady. Bite me, but still no buttercup emoji. Not yet. It's going to take hundreds and hundreds more members before they let me. Aaron Blackman says, why not put her on the stand? AJ, oh, we got this one. She took the stand, right? It's not that simple, unfortunately. I wish it was. Sandy, thanks for gifting so many memberships. Thank you. 20 memberships today from Sandy, at least. They cleared the street before the plows. We got that part. Dr. G, I think I got all the membership messages. I think we got everybody. All right, when we come back from lunch, AJ is going to take the stand. I believe AJ or Alessi. I forget. It's Alessia that's cross-examining, right? And it could be spicy, but she's smart. I think she's going to hold her own. She seemed nervous when she took the stand. She was not nervous when she finished. So we'll watch and see how that goes. It could be pretty interesting. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again in about 30 minutes with part 2 of day 11. There we go. Everything's set up. We're all good. Until then, get some lunch. Get some lunch. See you in a little bit. Bye-bye.